Wonderful. Well, we're right at the, just past the hour. So I see we have many friends joining us today and for this special session. And I really want to welcome everyone to the IFRRO International Conference. This is the first of a three-part program. And I know we have many different time zones here, and it's very late or very early for many of you. And I very much appreciate you taking the time to join. So on behalf of the IFRRO Board of Directors, the Secretariat, our CEO, Caroline Morgan, I would like to welcome you all here today. The theme for our international conference this year is Copyright and Collective Licensing, New Demands in a New Decade. And since we could not meet in person, we decided this three-part series over these few months in October, November, and December would be a good alternative. And you can see here, we do have a session coming up on the 10th of November on the UN Sustainable Development Goals. And this will be hosted, moderated by my colleague, Michael Healy. And this program will focus on best practices for 21st century RROs with case studies from RROs presenting best practices for implementing the UN Sustainable Development Goals, especially towards achieving quality education, gender equality, and responsible consumption and production. Publishing and reuse of content that advances diversity and equality in languages and cultures, including Indigenous peoples. So please put that on your calendar for the 10th of November. And then on the 2nd of December, we have a program, Moving RROs Beyond Text, which will be moderated by my colleague, Christopher Keneally. Here we'll focus on identifying new patterns of content creation, use and reuse, especially video and podcasts, addressing issues and concerns related to remote working and distance learning, which I think we all know so much about now, particularly the impacts on copyright and collective licensing. Video as the leading medium for education and entertainment, with a look at the impact on creativity and creators, importantly. And here we'll have an opportunity to spotlight storytellers and concerns related to the freedom of expression. So these will each be moderated sessions, panels of 45 minutes with Q&A included. For today's session, I have the pleasure of moderating myself and introducing three fantastic speakers who have generously agreed to join us. Our first speaker, KT Ang, is the Senior Vice President of Asia Public Policy at Universal Music Group. KT is responsible for, based in Hong Kong, and works closely with Universal Music Group's executive teams to ensure that UMG leads the conversation in creating an effective copyright framework and sound public policies to support a sustainable ecosystem for artists, creators, and the music industry throughout Asia. And prior to his time at UMG, he served as Asia Pacific Regional Director for IFPRRO, the global trade body for recorded music. He has a very full resume. Many of you may know him. KT was also the Asia Pacific Regional Director of CSAC for more than 20 years. So each one of these bios is quite impressive and long, but in the interest of our short time today, I will leave it at that on the highlights. Our next speaker is Ted Shapiro, who's a partner at Wigan in Brussels and the head of the office in Brussels, and has over 25 years of experience, recognized as a leading expert in international and European copyright law. His knowledge of the content sectors, as well as his commercial insights and deep understanding of the EU institutions, make him the go-to advisor for industry organizations and companies navigating the EU legislative and regulatory environment at the international EU and member state levels. He joined Wigan in 2013 from the Motion Picture Association in Brussels, where he was the General Counsel for Europe. He is a member of the UK Department of International Trade for the Cultural Industries Trade Advisory Group and the Law Society's EU Committee. Our final speaker today will be Dr. Silke von Lewinsky, who is the Senior Research Fellow of Intellectual Property and Competition Law at the Max Planck Institute for Innovation and Competition. Dr. Lewinsky is tenured at the Max Planck Institute in Munich and serves as a professor at the Munich Intellectual Property Law Center and as associate professor at the Zagreb University. She specializes in international and European copyright law. Bit of a legend there, I think. Dr. Lewinsky has consulted as a legal expert for the European Commission on a number of critical initiatives and for the governments of Eastern and Central European and former Soviet countries on copyright legislation. She serves as vice president of ALAI, which I believe just had their meeting in Madrid, and is president of its Germany chapter, and is also a member of the administrative council of the German Collecting Society Fage Wort, which is a member of IFRRO. So I want to welcome all of these speakers here today. And our very first speaker, who we'll go to now, is Kay Tian.
Good afternoon. It is great for me to join all of you in this discussion. It would have been even greater if we are now meeting in person in Singapore, with Glass being your host. But unfortunately, that is not to be. But we do still look forward to welcoming you to Singapore in the near future. Now, let me start by looking back on some historical facts regarding the music industry. Because I think while history can sometimes hold us back, it can also often be helpful when we're trying to plot our path ahead. Last year, the recorded music industry grows nearly $22 billion US. It was the 6th consecutive year of growth. And so growth started back in 2015 with about slightly more than 3% of growth. Prior to that, there were 15 long years where the industry suffered over 40% collapse in revenues. So it took 15 years for the music industry to put into place policies and legislations that now support a legal and sustainable digital music market, and to revise the decline that was caused by unimpeded digital piracy. So at the moment, we are 6 years into this new growth cycle. As some of you would know, this growth has been driven by streaming. Last year, it accounted for slightly more than 62% of total revenues. And looking ahead into 2030, I see this growing. I have optimism that it will continue to grow for the following reasons. Global streaming penetration is currently still in its early stages. Now, last year, at the end of last year, we had something like 500 million paying subscribers. Now, while this was about 30% growth over the previous year, it still represented only about 12% of the 3.6 billion smartphone users globally, or about 15% of the 2.9 billion monthly Facebook users. So that, and to put things in context, Spotify was started in 2006, so it has taken us about 15 years to reach the current stage where we are in. Moreover, if you look at territories like India and China, the number of paying subscribers is less than 10%. In addition, the value, the monthly subscription fee is also much lower as compared to the rest of the world. In fact, even in a developed market like the United States, current spending on music per capita is, last year it was about $37 US, and that is less than half of the $81 that was spent per capita in 1999. So no matter how you look at it, whether it is a developed market, whether they are the developing markets, I think the potential for growth, for substantial growth, is still there. So the number of paying subscribers can grow. And there is also significant growth in the ad-supported, legal streaming side of the industry, which will also be channeled into paying subscribers as we head towards 2030. So to me, that is the first shape of things to come as far as the recorded music industry is concerned. Next, we are now experiencing a lot of new means of access and also new ways of usage of content. To take an example, short form videos. It wasn't even an income stream, say 3 years ago, right? And studies have shown that currently nearly 70% of time spent on short form videos actually involve music dependent usages, such as lip syncing, dancing challenges, and so on. And then, of course, there are voice control speakers, connected cars, the intersection between social media and gaming, the expansion of streaming into new lifestyles such as digital health and fitness. So all of these represent new business lines, which I feel will come on stream as we march towards 2030. On top of all of that, of course, the very interesting topics of AI artists, AI machine learning created works, blockchain and NFTs. To me, all of these present themselves as opportunities and challenges for the music industry. And the way forward would be collaboration, coexistence, and to embrace and to adapt. Right? So the current trajectory towards 2030 looks promising, even though some of these new means of access or usage could possibly be disruptive. From the commercial perspective, I'll put it in simple terms. It means there are more business lines. Right? Let me now move quickly to share some thoughts on how all this may impact collecting societies. Now, again, looking back, last year, nearly 68% of total recorded music industry revenues were derived from digital sources. And the licensing of digital rights by major publishing and recording companies to the global digital platforms are conducted individually and directly. And of course, you have a lot of the smaller companies using distribution or aggregation companies to bring the music together and present it to these platforms. Now, despite that figure, nevertheless, over $2 billion US, or nearly 11% of global recorded music revenues came from performance rights, which are licensed mostly by the producer collecting societies. In fact, if you look at the 2 decades past, the growth and contribution in absolute and percentage terms by the revenues collected by the collecting societies have been very steady and very reliable. So it grew from something like $600 million US in 2001 to $2.6 billion in 2018. Now, obviously, COVID has impacted the contributions in 2019 and definitely in 2020. But despite that, the growth trajectory remains. So the first takeaway is the important role for collecting societies continue despite the fact that digitization has enabled direct licensing by right owners to a much larger extent. apart from the licensing aspect, I would highlight that digitization has also enabled and will continue to enable more effective collective management of rights. We have seen, and we will continue to see, improved accuracy and greater transparency in the distribution of royalties. And this, of course, means greater accountability as well. So to conclude on this point, I see a continuing role for collective management organizations, and I see better collecting societies that will utilize some of the same technologies like blockchain, AI, machine learning to perform its role more effectively and efficiently. Now, it is not all days of wine and roses. Piracy hasn't gone away. A 2019 music consumer study shows that nearly 30% of consumers still obtain their music from unlicensed sources. And this rises to nearly 40% for the younger age groups. So that will remain a problem in my view, as long as there's money to be made. Whether it's 2020, 2030, we will still have that problem. And while copyright has been, copyright law has been remarkably resilient and adaptive. Nevertheless, the laws, in my view, have not nearly caught up with the changes that have been brought by technology. And so this is an area that will need constant work in the coming years. And I'll just conclude by saying that, we truly live in interesting times. And I thank you very much for your time and attention. Thank you.
Wonderful. Thank you so much, KT. We're already getting questions. I just want to remind our audience that if you do have a question, you can just type it into the Q&A box, and I'm going to take the questions at the end. Next, we're going to go to our next speaker. If we can put the slides up for Ted. He has a couple of slides for us. Over to you, Ted.
Hi, everyone, and thanks very much, Tracy, and thanks to IFRRO for having me. We're going to have a little fun. I'm going to try something a little bit different. I'm going to try to connect you to via the ether to my future self in 2030. Just hold on a second. Things may go a little bit blurry. Hi. I know that I have aged incredibly well despite a recent bout with COVID-23. But welcome to those of you who have traveled via the ether from October 2021 to copyright 23, a scant 99 months in the future. Leaving aside the ravages of climate change, I'm glad that you cannot see out my window. It will not surprise you to hear that the pace of technological change has accelerated exponentially and has had a major impact on copyright again. We have also experienced the effects of legislative changes that were made, and in some cases not made, back in the time that you just left. The EU has continued to over-legislate and the United States to under-legislate. The European Court of Justice has continued to hear an endless succession of cases, while the US Supreme Court has been highly selective. In other parts of the world, algorithms fill in the legislative and judicial blanks. Regarding technology in the field, particularly in the field of artificial intelligence, it has made incredible advances, mind-blowing developments in terms of processing speed, bandwidth, frame rate, resolution, and dynamic range have been impossible to keep up with. Hardware is incredibly light and cheap. X-reality glasses, even XR contact lenses are ubiquitous, nearly invisible ear sets. Everybody has omnidirectional treadmills. Invisible start streams are household items. None of this is subject to private copy levies. X-reality technology has revolutionized all aspects of the sector that traditionally relied on copyright, including in particular the entertainment sector. Other sectors such as scientific publishing have faced their own specific challenges from the Sci-Hub Hydra, for example. AI tech entertainment companies are now dominant, mostly controlled by behemoths like Face, Amazon, Google, Apple, and Micro everything else. These companies have long since gobbled up the media giants like Universal, Warner, while Disney Flix fights on. Content remains king. Hyper-realistic games gobble it up. Content creation needs to encompass all user choices. Artificial intelligence thrives on data. Everything must be copied. Must learn more. Must learn more. Blockchain, and we're seeing content creation starting to do things. Virtual characters even commit crimes. Now, NFTs were big for a while, but the bottom fell out of the market, and now they are available in bulk on Face Amazon. Blockchain has proven useful in several content sectors, particularly for video games and for enforcement, but also as AK mentioned earlier, KT mentioned earlier, for collective management. CMOs have used these tools as well, much to their advantage. Regarding legislative change in the European Union, the 2019 DSM copyright and SACCAB directives perpetuated the trend in European Union copyright law toward weaker exclusive rights, exceptions on steroids for big tech, more reliance on remuneration rights, less contractual freedom, and watered down protection of tech measures. Now, admittedly, within the copyright world, different rights holders from different content sectors have always had different views, same as it ever was. Certain trends initially proved beneficial for those who rely on collective management, though of course one needs to keep an eye on the long-term impact for the various sectors, the opportunities for authors, and even the relevance of human performers. You may recall that the 2019 DSM copyright directive included a solution for the so-called value gap. It led to a shocking variation of national implementations, some of them disrespecting completely core copyright principles, though some member states still have not completed implementation of the directive. In any event, technology moved on quickly, and the new safe harbors and worthless due diligence obligations in the 2022 Digital Services Act quickly spawned new value gaps for which there were no legislative solutions or even messes. The Digital Markets Act proved to be a bit of a speed bump at best to big tech. The United States did nothing but complain to the European Union. The Court of Justice was busy contorting the communication to the public right and extending private copy levies to the cloud. But more recently, these levies have largely become derisory compared to the price of hardware and other exceptions like the great text and data mining giveaway of 2019, which really mattered to big tech. Other collective approaches have compensated somewhat. Most rights holders in the EU now rely predominantly on monthly checks from their CMOs. Meanwhile, in the United States, the failure to achieve any consensus on how to move forward on copyright issues has really meant that the status quo reigned, at least legislatively. The federal circuits began to strain with splits of authority, but the long-living Trump-appointed Supreme Court was much busy rolling back civil rights. Entertainment union strikes in the mid-20s also took a toll. At the international level, big tech and its client nations have been maneuvering WIPO towards a treaty on exceptions and the full repeal of exclusive rights and DRM protections enshrined in treaties from the last century when the earth was much colder. Not sure that the EU and the US can do anything about that, the cold and the treaties. Traditional copyright principles do still govern artificial intelligence. This has generally worked, but it has proven more difficult in jurisdictions where there were already way too many rights holders anyways. Now, some of you may see this as copyright dystopia. Others may view it as utopia. You could consult a human copyright lawyer, but they have become quite scarce and are incredibly expensive. A few years ago, a free AI app created by a former TikTok star went viral. It does the work of most copyright lawyers now for free. National Bar Association stopped trying to put the genie back in the bottle years ago. But hey, most people were already copyright lawyers back in 2021 anyway. So now I'm going to turn back over to my old self and wish you all from the future peace, love, and copyright. Thanks very much.
Oh, it's fantastic. Oh my goodness, Ted. I'm speechless. Fantastic. Wonderful. Well, we're going to have plenty of questions on that, especially on the long living Supreme Court. I have a few questions. I'm not sure if that was a horror movie. Okay, now we're going to move on to our final speaker, Dr. Lewinsky.
Thank you, Tracy, and thank you also to IFRRO for having been invited here to speak. I don't have slides, but okay. Between this rather optimistic perspective by KT and the, I think, the pessimistic one by Ted, I'm not so sure how to decide what side to take. In any case, what is clear, the next 10 years will be very dynamic, very dense, and the development, whether it will become rather good for right owners or critical and bad, in part will also depend on the activities and the engagement and alertness of right owners. So we maybe have some possibilities to try to avoid the worst scenario. But looking ahead, I think it makes also always sense to look back and like KT did, in order to see where we come from and where it might go to. And interestingly, I also thought of the time period of 15 years, like KT. It's a good time span because that was around the time when all of a sudden the copyright discourse changed from a situation where nobody had put into question the fundamentals and the justification of copyright, but voices came to be read and heard about overprotection. We need the free flow of information, although information, what they meant were works created by humans. The free access mantra is still dominating today. It was around 2004 when Lawrence Lessig, by the way, a constitutional lawyer and not a copyright lawyer, first published his book entitled Free Culture, How Big Media Uses Technology and the Law to Lock Down Culture and Control Creativity. So you can see the negative tendency of that one. And even the New Yorker considered Lessig as, quote, the most important thinker on intellectual property in the internet era, unquote. So that was a little bit part of the beginning, and it set the tone for many years in the copyright discourse, where we newly had to learn about words like copyleft, which we didn't know before. Well, why? Of course, because the internet has offered so many possibilities for everyone to upload, to access works. This was the beginning heaven on earth, or in the internet, for users, and of course also for the internet service providers behind them who had the same interests, because more traffic on the net is more money for them. And maybe also the right owners were a little slow in adapting to this new challenge in offering their own new business models, so that too long time has passed in which the users could have limitless and gratuitous free access to everything. And this made afterwards the enforcement even more difficult because the atmosphere was so much against right owners that even artists didn't dare to say anything in the internet, on social media anymore, about the need to earn some money through copyright protection. They were really bashed to death and would not dare to say anything anymore. But a little bit like KT also, I think he also chose the time of 5 years back, where a new cycle has started slightly. And I see that in global, overall also, as the time when you could observe artists again took the courage to assert their rights publicly, to say, well, there's a justification for copyright and it is a good thing. The discourse slightly started to change. And why would this be? I think because more and more people then realized that to a large extent, the GAFAs of this world, the big tech, are behind this copyright hostel discourse, and they came under pressure also because of reasons outside of copyright, which will help copyright. Just to mention personal data protection, hate speech, tax avoidance, etc. And among others, also the lobbying influence, which is really a fantastic empire which the GAFAs have built. And this came out only some 5 years ago. There was the so-called Google Transparency Project, which is today called the Tech Transparency Project. It was launched in 2016, 5 years ago. And at the time, or it describes itself on its website as, quote, being then a lonely critical voice of big tech, unquote. So this has changed. Today, they are no longer the only ones. We have just this year another report on the how Google and co influenced the EU by the Corporate Europe Observatory, together with lobby control. There are more and more revelations. The Google Transparency Project published a report in 2017 on Google Academics Inc. Where they revealed how strategically or how intensively Google has been cooperating with academics who then received money for publications but did not often reveal the source of this support. This has been added by the event in the lobbying in the framework of the DSM, which was very well found out also by an investigative journalist that all these mails put to MEPs and threats, and the whole campaign was rooted in certain NGOs behind which you could find Google most often. So, and this became clear to many, and I think this changed the thinking of many. It made it so clear to everybody that we are in an environment today where this has to change. And indeed, the European Commission has put out the digital single, the DSA and the DMA projects in order to regulate the big tech better, in order to get rid of such negative side effects, let's say. And I think that is important for the next 10 years. Where will it go if the legislators will be still influenced by many hidden ways and by so much pressure? Then our copyright legislation will be, like Ted said. That is a big danger, and we have to stay alert. And I'm not yet sure whether it will be possible to manage this problem, because already the lobbying force also for the DMA now is so big that I'm not sure whether there will be a change. But maybe, at least the awareness is there, and that's good. Otherwise, on AI, yes, this is a big challenge. Again, the big tech have an interest in getting free access to make copies for the machine reading, which is necessary to produce afterwards AI products, also in music, texts, art, etc., because it will bring them a lot of money. And I think we should fight against getting broad or limitations. We have some already in the EU now, but this should be stopped or hindered because it is unfair to give them free copying possibilities, even without remuneration. And then all these works which are fed into the machine learning and which will produce products afterwards, these products will compete with the original works on the same primary market. And well, this is just unbalanced, and I think there should not be given so much leverage to promoting such products. But there are many more connected, also practical problems between AI products and human products. In general, to finish, I think we will ever see more new business models. There's so much exploitation on the net going on in the digital environment, ever more varieties of that. And I think today, right owners do not always still sufficiently well benefit from such exploitation. There are many examples up to the cloud copying. We have a case now pending before the European Court of Justice to see whether there should be money paid for private copying going on in the cloud. There may be podcasts being downloaded. Well, how do you measure if that's even a practical problem? How do you measure how much is being copied by whom in which country in order to distribute monies or collect them in the first place through collecting societies? So especially for collective management organizations, there's a lot of challenges. But I will stop it here. Thank you.
Thank you very much. Thanks to all of you. Certainly there are a lot of challenges ahead, and I can see in the notes here in the Q&A that some colleagues, Ted, after your presentation, are feeling relieved that by 2030 that they will be retired, maybe possibly along with you. So that was a little bit of a joke, but a funny one, I thought. But we did have a serious question, Ted, for you. Does your dystopian vision for 2030 mean that you don't have much hope that the Tillis bill on Section 512 in its attempt to rebalance the US safe harbor regime will proceed? Any thoughts on that, Ted?
Yeah, sure. Well, I would say first that my dystopian view is meant to be a bit of a warning. I would also associate myself with a few of the things that Zilka mentioned. Doesn't have to be this way, or that way.
Right.
That said, I don't have much hope for the Tillis bill. I'll obviously defer to my US-based colleagues who are much closer to the situation. My experience, and it's been again more from watching with U.S. copyright legislation, I was sort of alluding to this in my presentation from the future, is that generally the U.S. legislator likes to be handed an agreement by enough of the grown-ups in the room, by enough of the if there's 3-4 sides to an equation or whatever, the main players need to hand them the legislative solution. They need to know there's consensus. Without that, it's very, very difficult to advance legislation in the United States. If you own a senator or two, you'll block it. And so I am dubious about that in the absence of consensus, really with copyright owners and big tech. In particular, there are a few other grown-ups in the room too.
Great, thanks for responding to that. And I want to invite anybody in the audience to send us in a question through the Q&A, and we will address those questions. KT, I had a question for you regarding the pending new Copyright Act in Singapore, which apparently it will allow text and data mining, which extends also to music and audiovisual content, even from illegal sources, as long as the user did not know the sources are illegal. And could you address this? And what is Singapore, how is the market in Singapore going to be dealing, how will this impact the market? How will they deal with this? And in general, the market has been looked at as the gold standard here. So, what do you expect?
Well, I think a lot of the copyright industry representatives lobbied heavily against this particular provision. Unfortunately, very unsuccessful. And as some of you would know, the law was enacted last month, and it will come into force in November. So from that perspective, we have to live with it. It is, it has become law. And I think, as Ted mentioned, with some of the issues, there seemed to be a repeat of what happened in the past when tech, big tech first started, and it seems some lessons have not been learned. The intention appears to allow mining of big data, so as Silky mentioned, so that they can come up with their own creations, which they are obviously going to make a lot of money from it, at the expense of copyright owners and content developers. So I think the situation is unfortunate. The chances of it being replicated elsewhere in the region, in my view, is relatively high. Because bear in mind, Singapore is part of RCEP. There are 15 countries involved in that, right? And other trade agreements. So I think the odds of other countries looking at it, and of course competing for big tech to be based there so that they can, create jobs, mine data, create something for the future. So to me, the odds are relatively high. And I think we have, as content owners, we have no choice but to really hopefully persuade, as many governments as possible that is not a good way forward. The interests of content creators have to be balanced against what you want to achieve with big tech. And I'll stop there.
Thank you. Well, that sort of brings me to a question I'd like to ask you, Silky, but then ask all three of you if you could comment on. Silky, you talked about, and everybody talked about big tech here, and the appetite. Could you comment on the appetite of Western governments to confront the power of big tech? Could you comment on that a little bit further? I think we heard a little bit of potential dread in Ted's forecast or his view of what it might be, or hope what it won't be. But I'm also thinking about if we think about 2030, what do you think the balance of power will be between rights holders and the tech platforms? And what do we do now to impact that? Is it like climate change? Are we just kind of on this trajectory and there's just nothing we can do? The planet just continues to heat up? Or could we do things now that, as concerned members of the IFRRO community and the broader copyright community, to impact the outcomes in 2030? So let's start with you, Silky, on that, and then I invite Ted and KT to weigh in.
Thank you. It's an important question. I think it goes much beyond copyright. So the copyright community can do little things. But the most important things would come from an overall maybe regulation or even more transparency with lobbying, from activities like the DSA proposal and the digital market proposal from the European Commission. Though the big question here is indeed, are big tech already too big and now already influencing even these projects so much that they will not be able to change fundamentally the way in which these lobbies exercise their power? It depends on the members of parliament, whether they really stay strong. It depends on governments in the same time. If we have a general atmosphere like for climate change, where everybody in the street says we need to change that, and maybe we have seen the beginning of that, this would give me hope. So if the big tech cannot get the population anymore in overall to be with them, but to be critical, then there's a chance that also the legislation will be better in the sense that the lobby power will be better controlled, the financial aids, etc., and that there will be more transparency and more revealings, so that the legislators will be more independent, let's say. But that's a big challenge. Awareness is the first step and activities thereafter is the second. although we read already that now Facebook has said, oh, first they didn't like regulation, now they say, well, we welcome regulation, and of course only if regulation happens the way they want it. So it continues. They will never give in as long as they have so much power. A good thing is also that the pressure is put on many cartel offices in the world, so that the competition law angle comes in, which might help to some extent. But we are now really at a crossroads where I think legislators have a big responsibility to really look at the matter and not to be seduced or persuaded by arguments which you hear ever again in the lobbying, like, oh, Europe will be back if you don't do this, back behind China and back behind the US. And I mean, there are these arguments coming up and trying to threaten European legislators. This has to be made clear what strategies are behind, and so it's a much bigger problem than just in copyright. But I'm already happy to have heard from the European Commission that they do not intend in the coming years to continue with major copyright legislation, because in the coming few years, I think the situation is still not good for copyright, and one should rather not start legislating now, because it will rather go down for the copyright.
Thank you. Ted and or KT, you want to weigh in on the balance between, or balance the ecosystem of big tech and rights holders if we look ahead to 2030?
I defer to Ted.
Okay. Well, I mean, I largely share the analysis of Zilke. I'm very concerned, in particular, if we look at the Digital Services Act, the direction of travel of that piece of legislation since it's been proposed by the European Commission, both on the Parliament side, as everyone will know, when a piece of legislation proposed piece of legislation comes out from the Commission, it's sent to the co-legislator, the European Parliament, and the Council, which is the member states, and they deal with it on a kind of parallel track. So people that are watching this legislation will be watching those two tracks. In both cases, I see a lot of worrying signs. An example is basically there's been questions about where safe harbor, where search engines fell in the general scheme of things on the safe harbors. And there's a proposal to drop them into the caching safe harbor, which I think would be a step back. In the United States, search engines have their own safe harbor information location tools in Section 512, but it's constructed very much along the lines of the hosting safe harbor. And I think that's what the Court of Justice has considered it to be, and probably the Commission in its impact assessment. Now, that's just one example. There are a number of other areas where we see the DSA, I think, going the wrong way and has the propensity to create what I call new value gaps. The DMA, probably less bad at this stage. That the question becomes whether it's going to be enough. Many of you will remember that, you know, one of the most successful things in the United States decades ago was the breakup of Ma Bell. That had huge benefits for the industry itself that was broken up and at the time thought it was going to be the end of the world, but for consumers, for innovators, for copyright owners, for everyone. Now, breakup, the notion that the governments of the world are going to break up some of these companies seems quite amazing, but that is the step that I think would be necessary. Albeit politically very, very difficult to do. Europe has a unique chance of being able to do something more than I think that the United States will be able to do in the first instance. It's not for nothing that many US companies come to Brussels to make competition law, antitrust law complaints against big tech. But hopefully US antitrust law is going to have a wake-up call. And be, it's been asleep for a few decades, and maybe it could start to do something too.
Well, let's hope for that. But let's keep Brussels going while because we need it. Okay, KT, did you want to add anything in, or should I go on to another question?
Please, go on.
Go on. Okay, we do actually have several other questions here. One comment that's just coming in relation to what we were just talking about is, and I think speakers could see these in the Q&A themselves, but one of our audience members is saying maybe the answer comes from video games. Their crowd gaming is largely immune against copying, so maybe the only way to survive in a creative sector is the gamification or virtual realization of entertainment and the content sectors. Essentially, the defense against the gig economy is to be a gig that cannot be replicated, like esports and etc. I thought that was kind of an interesting comment. KT, we do have several questions for you, including a question about streaming. And do you have any comments on the low penetration of streaming music in India and China, where mobile phone ownership is ubiquitous? Do we have the wrong business model, or is there perhaps a more entrenched culture of infringement? And what could be done to address this low penetration?
Perhaps I will start with a clarification. The penetration of streaming per se is actually fairly deep. The point I was making is that less than 10% are the paying subscribers. And yeah, and one of the challenge is, one of the key challenges is this, the free and legal model is so good, the consumer don't see a need to go towards a paid model. And then of course, there are challenges when you operate in either of these two territories. Pricing is always a big issue. You don't want to go too cheap. You also don't want to price it too high. And that's all. So again, there are benefits to that in the sense that in future you have growth not just in number of subscribers, but also in pricing. So I think we can look at it positively from that point of view. So I think that is what is happening with the streaming market. So actually, to make it clear, a lot of the consumers in both territories, more in China than in India, are actually accessing legal content now, but it's free. It's ad supported. Question is, how do you derive or drive them towards paying for the subscription?
Great, thanks for addressing that. And for that clarification as well. And we are nearly out of time, but I did want to pop one more question in. Everybody talked about artificial intelligence, I think, today, and we could have a session just on artificial intelligence. But do any of you want to comment on how the copyright system needs to evolve to address and manage AI? We talked about human created content. We also have human consumed. We have machine created, machine consumed. Where are we, and how do we need to think about the huge factor of AI going forward in this next decade? Any thoughts?
Well, if you want. The discussion will go on these two aspects. The one is, of course, the input, which I mentioned already. You need from the machine learning, which is necessary to apply the AI. You need to copy lots of works. And for me, that is a reproduction. And then the discussion will be, should there be an exception or limitation or not? As we have regulated, well, an exception unless the right owner poses in a certain way. We will see how this can be implemented in practice also. Again, I think one should not really extend such exceptions to other countries, because one has to ask why. What is the justification for such an exception? Just to promote technology, you don't need that, because you can take public domain works if you want to test and promote the technology as such and the innovation as such, as the big tech always say as an argument. If you want to promote the production of artificial music and so on, is it really necessary? Is it at the expense of human creators? I also learned that AI is actually not intelligent, but dumb, because it recycles existing works. For me, it's a recycling. It is not really what we would call creative and what humans have done in creation and having new, works deviating from what was there before. Does it really, so the question is it really useful for the users also, for the consumers, to have those same mixed up again? That's the one side, and the other side is, of course, should we protect the products? I don't say creations by AI, but it's still not human made, so the products of AI, I don't see a need for that either. There's a big investment. There could be a related right, certainly not a copyright in the droit d'auteur countries. But even for a related right, there must be a special justification to protect this investment. And this is very doubtful in my mind. So I stop here.
Thanks, Silke. Any other comments before we wrap up?
I would just add that I mean, that's why I suggested in my future self suggested that traditional copyright principles can govern AI. And one of the main reasons I said that was for the same fear that Silke has, that if we open up this issue to legislation, we won't like the result. Because we'll get a big exception that is not necessarily and not justified. The commercial text and data mining exception in the 2019 directive is a travesty. That's basically a giant gift to the richest companies in the world. It's just unbelievable. And so that would happen again, and we can figure out who owns this stuff on the basis of work made for hire principles in some countries, related rights principles in others, as Silke has suggested. We can deal with it, so let's not legislate it.
Wonderful. Okay, well, I think we've coined a new phrase here today, which is maybe AUI, artificial unintelligent. So on that note, I think we're going to wrap up, and I want to thank all three of our speakers. Thank IFRRO for coordinating and hosting this program today. And I would also like to ask you to mark your calendars for the 10th of November, where you can join us for a program on the UN Sustainable Development Goals. And you can also find more information at ifro.org on this. So thank you so much to everyone, and wishing you all a great rest of your day. Take good care. Bye-bye.
Thanks. Bye, everyone.
Thank you. Bye-bye.
Bye-bye.